Welcome to ASI Legal's online learning platform. I'm Anthony.
I'm Isabel.
And I'm Stephanie.
And today we're going to be taking you through lawyers' duty of confidentiality and lawyers' use of media.
After each question, there will be a short pause to give you time to select your answer.
You and your associate are at court waiting for your client's case to be called. In the meantime, The correct answer is C, not use social media at all. When using social media, the Law Institute of Victoria has advised lawyers to exercise extreme care. Due to the risk that confidential information may be disclosed, the best practice is to not use social media when working with your client. By way of inadvertence, you may unintentionally reveal to others the identity of your client. Despite your intentions, such an incident would be a breach of confidentiality under Rule 9 of the ASCR.
The relationship between the duty of confidentiality and legal professional privilege can be described as The correct answer is B, closely related with fundamental differences. While the duty of confidentiality and legal professional privilege both seek to protect information confidential to the client, it is important to note how they differ from one another. The duty of confidentiality is one of the most important duties you owe your client and can extend to cover a broad range of communications. Legal client privilege, by comparison, is a substantive right that your client is entitled to. It is important to note that privileged communications will be confidential. However, not all confidential information communicated over the course of your engagement with a client will necessarily be privileged. This is because they are not subject to compulsory disclosure requirements in the same way that confidential communications are.
Some of your clients' previously confidential information has come into the public domain. You should. The answer is C. Continue to regard the information as potentially confidential and only disclose it with your client's informed consent, as your client may perceive a duty of loyalty to be owed by their lawyer and thus feel betrayed by your disclosure, especially because the information in the public domain may not be entirely accurate. By giving weight to what may have been partially unsubstantiated information, you may disclose something confidential, especially where you opt to correct information without client consent. As lawyers' knowledge of their clients' affairs is likely to be more extensive than published information, there remains a danger of inadvertent disclosure of confidential information.
You have just completed the third day of a 5-day trial. Outside the court, a journalist approaches you asking about the validity of a witness. You should. The correct answer is A, decline to comment. Under Rule 28, lawyers are prohibited from making public comments during the course of a proceeding. Doing so may influence the capacity for a fair trial and cause a miscarriage of the administration of justice. Even in situations where you believe your comments are public knowledge, it is best practice to keep silent, as such comments may give credit to other claims and allegations. In 2009, a lawyer representing Chappelle Corby was found to have breached his duty of confidentiality by disclosing the previous criminal convictions of the Corby family during a television interview. He had obtained this information in private conversations with Miss Corby and her family, thus making it confidential.
The source of lawyer-client duty of confidentiality is found in The correct answer is D, all of the above. The source of the lawyer-client duty of confidentiality is found under contract law and equity and the professional conduct rules for both barristers and solicitors in each jurisdiction. It is important to note that the source of the duty of confidentiality also speaks to its scope. For instance, under equity, the protection for confidentiality can subsist beyond the death of your client if that information continues to be considered confidential. It should also be noted, however, that information that falls within the public domain and is thus available for public access does not necessarily extinguish your duty of confidentiality. Disclosure of information that you consider to be public knowledge through a media platform will still be considered a breach of confidentiality if that information was conveyed to you by your client on a confidential basis.
The legal professional rules entitle lawyers to disclose confidential information. The answer is C, both A and B. The ASCR provides this stringent exception to disclosure of confidential information with the Act's glossary defining serious criminal offence. Additionally, the professional barrister's rules prescribe where a barrister whose client threatens the safety of any person may disclose confidential information to advise the police or appropriate authorities.
A case of yours has recently been adjourned for a directions hearing. On Instagram, you receive a follow request from the other party. The correct answer is B, decline the request. The Law Institute of Victoria has deemed accepting a friend request from a client of another practitioner to be highly unethical. Such an action would be a breach of Rule 33, also known as the no contact rule. Lawyers should avoid any kind of contact with the other party at any cost. Likewise, lawyers should refrain from making friend requests to other parties in order to get access to the social media pages.
A key rationale underpinning the duty of confidentiality states: the correct answer is C. The duty encourages full and frank disclosure between client and lawyer. It is hard to overstate the importance of understanding the duty of confidentiality in your role as a lawyer. As lawyers, you are now equipped with special knowledge and skills, and with that comes a duty to serve your clients, and by extension the community at large, by upholding the administration of justice. This duty overrides any duties owed to another client, death of a client, or termination or cessation of a retainer. It is important to be aware of the consequences of breaching your duty of confidentiality, particularly through inadvertent disclosure of confidential information. This can leave you open to claims for damages in negligence, breach of contract of the retainer, and loss of reputation.
A solicitor may not disclose confidential information if the answer is D. The solicitor is trying to impress a rival solicitor by boasting about their client's new product. Breaching confidentiality for any reason other than those prescribed in Rule 9.2 may leave the solicitor open to claims for breach of contract, tort, or equity.
You just received an unfavourable judgment from a magistrate who you found to be rude and intolerable. In response, The correct answer is A, lodge a formal complaint. Under Rule 3, your duty to the court is paramount despite your disapproval of any of its decisions. By posting negative comments online or sending an email to your firm, you'd be breaching this duty. Such actions lack integrity and bring the profession into disgrace. In a US case, a lawyer lost her position and was suspended from practicing for 60 days for labelling the judge clueless on her blog.
If a lawyer's duty of confidentiality lies in equity, there may be grounds for recognizing the public interest defense to disclosure in breach of confidence matters. The answer is true. As equity's role is permissive, there is a heavy burden on the lawyer who discloses confidential information to establish the defence. It should be acknowledged that Australian courts have not given unqualified recognition to a broad-based public interest defence. Instead, they recognise that there is no confidence as to the disclosure of inequity and confine this concept only to serious crime.
Thank you for watching. We hope you found this video instructive and can continue to build on these areas of expertise and others in your practice through our online content.